very large gathering in spite of the rains. I think that is because one of our own is going to be addressing us. So it feels good. Anyway, a warm welcome to everyone, to all the mediators in the Gulbarga and the Dharwad benches and from all over the state. A warm welcome. Today's the key speaker for today is Madam S.R. Anuradha. She is a lawyer practicing in the High Court for the last 28 years. She's a designated senior counsel. She's been a mediator here since 2008. She's also a potential trainer with the MTPC. She has done several uh, courses. This is, I have known Anuradha one person note since 1988. So it is a lot of affection and pride that I welcome her today. And since 88, her energy is something that is unlimited. So I'm not surprised that at this stage of her career, and a career, there's nothing else she's got for her experience, she still seeks to learn and has taken up this course during the vacation. I think it is commendable. Uh, you say this is a fourth. Anu has penned many articles on various law subjects in various journals. She is a visiting faculty in the University Law College. She's just completed her mediation intensive training program on negotiation conducted by the Harvard Law School. Madam Anuradha has trained many advocates to become mediators and it also conducted several awareness programs for federal judges and young mediators. Today she's here to share with us her experiences and learnings from the Harvard Mediation Intensive Program. I think this is wonderful because, it's always uh, very encouraging that we see someone, one of our own, going and studying and learning and acquiring knowledge. In fact, half of us were discussing in the room, about going somewhere and 6 weeks of training programs are shared. On behalf of the Karnataka Mediation Center, a warm welcome to the Dharwad, a warm welcome to the Dharwad and Kalburgi Bench Mediation Center and the District and Taluk Mediation Center and all the mediators present in person today and virtually. I also welcome the Honorable Judges and Principal Judge, Bangalore, Dharwad, Kalburgi Bench, who are just work today. Yes, I did the Raja and the I think was part of the rather than the take this opportunity to welcome our new Deputy Director, the S.S. Bharat, Senior Civil Judge. Welcome, sir. And I hope this welcome to the engagement family, and I hope our interaction will be helpful to both of us. Thank you. Technology is always something that we tackle with. And let me tell you, even if we are experts, it will give you something that so, yeah. So I thought I shared few anecdotes about how this power thing really happens. Am I echoing by any chance? Or are you all comfortable? Yeah? Okay, na? All right. And there are some beautiful cases hidden behind the uh, pillar. So you can either, yes, thank you so much. So, yes,
Yesterday I asked my husband, giving a talk today, ಏನ್ ಹೇಳಲಿ ಅಂತ. ನನ್ಗೇನ್ ತಂದ್ಕೊಟ್ರು ಅದನ್ನ ಹೇಳಿ. So, so I wanted to be a student again. And when I was in college, my dream was to go to Harvard and study. Some of my classmates or college mates were here, they can remember Harvard ಹೋಗ್ಬಿಟ್ಟು ಅಮೆರಿಕಾದಲ್ಲಿ there is an ex firm. I don't want to know. I'll tell them. And I got a letter. I applied and I got a letter. I still remember the name of the person. He was Matthew Logan. He said, your profile is very good. We have put you on waiting list and we'll let you know soon. So I was really happy. And somebody told me waiting list for Happy you're not going to get it. There's a lot of free was forgotten. So when I did this course, I want to confess, mediation is something which has made me recognize myself. That is what eco ಬರ್ತಾ ಇದೆಯಲ್ಲ. Now, I think my voice, like that one is much better than with my, I think this is better, right? To raise my voice. I think because I'm having the mic also, I think it should be fine. So let me just complete that. So, where was it? Yeah, mediation, how it changed. So when, yeah, oh, oh, yeah. So I came to know that they used to do only programs on negotiations. That means if you can become a good negotiator, then you can take. So it was a 1 year program and then it shortened. I had applied in 2016 and I was not accepted. In the sense, probably they had too many. 2020, when I applied, they said, yes, you're accepted. But we couldn't go, COVID came. Then I thought, may not be. I'm not destined to go to Harvard. So then this year, the good thing was the in-person course of 2 weeks was in May. It is never in May in, in Harvard. It's always in June or July. I always was thinking, how can I miss court and go? But in the recent years, I had made up my mind I'll miss court and go 1 year. But this year, it was in May. The minute I saw it was in May, I assigned for it and they also accepted immediately. Then the question came, who will go with me? Then my husband was hoping I will tell him we will go together. I declared I want to be a student and I'm going to stay there 2 weeks just for myself in student accommodation. Of course, this was a little upgraded student accommodation, so I could not like what I stayed when I studied in England. So he didn't have any say. He said, okay. So when I came back, I brought him one t-shirt and one topi. He told me, ನಾನು ಟೋಪಿ ಹಾಕಿದ್ದನ್ನ ನೀನು ಎಲ್ಲರಿಗೂ ಹೇಳ್ಬೋದು ಅಂತ. The learning that was is that what dream I left, it was not happening. I feel today I had a better life here. I couldn't have had this kind of life 50 years that I lived here. I don't think I would have had this kind of life ever anywhere else in the world then. And at the same time, the time came when I really could also fulfill that dream. It only reinforces that the dreams that you dreamed are lesser than what God has dreamt for you. So that was a nice thing about this course and more experiences I will share. And I was wondered, what is it that I can talk about? And before I go into the subject or share with you what I have, I think I should take this opportunity that it was really commendable of the governing council and our director to have given me this opportunity to stand before you all. It is a humbling experience because you are the people whom I move around with every day. And then today you have taken out time and I'm sitting here to listen to me. I don't know if I'm going to make you if I can enrich you in any better than what great knowledge you already are having. But I would try my little bit and we'll see where we go. What are my primary goals today? The concepts of mediations are nothing very great or different than what we have learned or what we've been teaching you on. My primary goal would be to give you better phrases than what you had with you while you are doing with your mediations. And probably fine tune a little bit of those theories, what you are doing or what you are conducting now. And what are the areas of growth? That is for you people to figure out what areas you have to grow as I speak to you all. I can't tell you. And then we'll see how we can sum it up. So there it is. That is for people who would like to see how the Harvard. So there were two classes. One is master negotiation class, which overlapped with my Harvard Intense Mediation. So this is what is the course, that's the certificate that I have. It's on its way, it's yet to come. When it comes, then I will share with you all. There you see, that's where we used to have the classes every day. And yeah, probably you could probably take note of this. These are the books that I feel that you all should read by Audrey Lee. Audrey Lee is a faculty at Harvard. She's a trained, seasoned mediator, a very cheerful lady, and she was one of our persons who managed the whole course. She and one more was Alan Repair. I will show his photograph also for you. So these are some of her works. I've only taken the work that I felt that is helpful. Turn and voice that is there. So that is the famous David Hoffman. How many of you know of David Hoffman or read about him before? Who has read David Hoffman before? Anybody in the crowd? Okay. So David Hoffman is one of the pioneers in mediation in America. He's written plethora of books. And he was one of our resource persons. He spoke about uh, implicit bias and ethics in mediation. And his famous book is 10 Principles of Mediation, which I will I'll share it with all of you. Then he next had, this is Andrea Lepore and Rob Moonkin. Rob Moonkin was a mediator in the software dispute between IBM and uh, Fuji, uh, the two great software companies. For 11 years, he has mediated as to how they will share their software rights. So he's written a book also on that. So he is one of the advocates for non-caucus mediation. When I say non-caucus mediation, it's a joint session mediation only. That means you conduct your entire mediations only in joint session. This, he says, brings about a lot of transparency in mediations. When you have more caucus mediation, that is private session mediations, the advocate becomes like an agent between two groups and trying to bring them all at one platform. And that, in his opinion, is not the mediation which they envisaged in the 1970s, 80s. So he's one of the earlier pioneer persons in mediation. And Alan Lepure was another resource person for us who has done mediations between Nicaragua and the United Nations. And he's also a faculty at Harvard Law School. Now, he's the man of the hour, William Ury. Anyone has read about him before? Yes. Yeah. So, what a personality, 70 years, you can't make out. So, he's the founder of the programs on mediation. I recommend you all, highly recommend you all to read this Getting to Say Yes and Power of a Positive No. You have YouTubes also, which he has given. So he was the pioneer guy who mediated between USSR and USA in the Cold War. And he is one of the founder members who started this course in Harvard. So meeting these people, interacting with them on a daily basis, and just generally talking to them, I think was the best experience. And I can't share that as an experience that I enjoyed. I really can't share that with you, but I'm sure you'll all feel happy that I participated with them. So, friends, this is the 16th century building in Harvard. And can you believe out of 300 years, this was the first time from past 6 months, this building was closed. These gates were closed because the Palestine and Gaza students had a demonstration that literally put up tents. I just didn't want to show those pictures. So whoever the student like us, with our ID, we could just go around and come. But otherwise, mm, they said that Harvard was never ever closed. But in the past 3 months, the week I was leaving, that is on 18th, 19th, that weekend, they were vacating. So this was, in a way, I went at a historic time, you can say, but it was not good to see so many people just squatting on the campuses of such a great institution. So mediation in United States. I don't want to take much time telling you all. I only want to say it's a mediation process that has organically grown. People just learned mediations by themselves. Now they have courses. When we also had courses after 2000, before that they had no courses at all. People just learn from one another like a Guru Shishya thing. And it started sometime in the 1970s. So in all the Bay Area and Boston area, wherever they had interactions with people from overseas. So at that, wherever the dispute happened, they employed mediation there. And we also had people from the Bay Area who came and taught us when we did. Even today, they don't have any enactment to govern them. So how are the mediators governed? Only law firms or administrative firms who have mediation as a part of their firm, they have their rules. By and large, now it's uniform everywhere. They are governed by those rules. That's all. There is no governing body for mediations, and they want it like that. In the year 1998, that means almost 30 years. So mediation started in the United States in the 70s. So almost 30 years later, the federal government passed the act called Alternative Dispute Resolution Act. Technology is it. Is everybody comfortable? Thank you. So this Alternative Dispute Resolution Act of 1998 is the only enactment which empowers the court to send cases for mediation. So the only court annexed mediation comes under this act. And there are no rules, nothing. They just send it. They, and in case the court, and I mean, the judges themselves sit as mediators under this. And in case the mediation doesn't happen, the judge will give a judgment. Same judge. So that's what was Mr. Hoffman was saying that this is one of, yeah, all the states, all court annexed. And thanks, my name, I forgot your first name. I'm in Harvard, you see. Thanks, Rukmini. So see, all states, there are 54 states there. So all states need not necessarily have mediation. So it is still a growing process. The entire mediation concept is with the private people. It is government has no participation in it. It is only under this Act, the 1998 Act, it empowers the courts to send it for mediation. Adu ಎಲ್ಲಿ ಕಳಿಸ್ತಾರೆ ಅವರು? They will send it to one of these firms. And that will finish, or most of the time, the judge himself will sit as a mediator and mediate. And in case mediation doesn't happen, he gives a judgment also. So that was what Mr. Hoffman was telling, that this is something totally unethical, which is happening in our country. And I proudly told him that in our country it doesn't happen. So that was one moment of cheer for me, that I took that opportunity and raised my hand and said, we do have rules and ethics where our judges, if they sit in mediation or if they sit in judicial settlements, then they are not to take those cases. So that was one good thing. Now, this is a nice definition of mediation. If the three aspects which are there here in mediation, I mean, four, you can see it here, which I liked it very much. Somebody wants. Mediation is a voluntary process in which the parties make decisions together based on their understanding of their views, each other's, and the reality they say. So you have a voluntary process, you have a self-determination in this, then you have understanding of the views of one another. This communication and then reality that they think. So all the IFM, all the concept of mediation was put in. This is definition given by Mr. Bob Mumkin. So long as I'm using this to educate people, I will not be violating any of the copyrights. Now, what I saw there was they never used the words compromise or settlement. These two words, I have never heard them speaking in the 2 weeks that I was there. Any resource person who came, no word of compromise, no word of settlement. The key word in mediation is understand. You understand the problem, you understand the parties, everything you do is understand. And when we sat with live mediations, we could see the mediator say, as I understand you, is this what you mean to tell me? So I feel the only difference between them and us, if I can say, is we are a bit crude in our language. While I say we are a bit crude in the language, that is everything in mediation. So using the right phrase is very, very important. And that was also one of my. We have to make that conscious effort to use the right phrase. Whether you speak in Kannada or you speak in English, you have to find the right way. ನನಗೆ ಅರ್ಥ ಆಗಿದ್ದೇನು ಅಂದ್ರೆ ಅದ್ರ ಬದಲು ನೀವೇನ್ ಹೇಳ್ತಿದ್ದೀರಪ್ಪ ಅಂದ್ರೆ can you see the difference? That's what I'm trying to tell you. So this makes an impact on the parties. We feel that it won't make an impact. It does make an impact on the party when the mediator uses the correct phrase. And today I'm going to give you many such good phrases which probably you can translate in our local language also and use. So next I got this very nice definition of a mediator. A mediator works as a non-coercive neutral to help the parties negotiate an agreement that serves them better than their alternatives. So here you have the neutral person, and then they concentrate more on negotiating an agreement. We are concentrating more on, see, our mediation tactics is more of an altruism mediation, if I can say. There are many seniors here, so if you all feel that is correct. We are like more altruism mediation. They are more commercial, negotiated oriented mediation. So they are like result oriented mediation. We are like, I mean, what we have been taught, I don't know how we are utilizing it, but what we have been taught. So the neutral person facilitates for a negotiation and serves them better than their alternatives. So they are always evaluating with their alternatives. So the mediator makes them to evaluate which is my better alternative. Can I sit here and decide, take it, or shall I go to court? Or can I look at some other options? So the mediator helps that parties to go on evaluating. And that is with what? Evaluating with what is the status of their case, evaluating with the alternatives that they have. If they're getting something better somewhere, they're not going to sit in front of you. So, a duty of a mediator is to always help them to evaluate that this is the best place for them. In agreement, we always, again, I said, we always say, now, settlement, now, agreement in gain, because compromise agreement. And unfortunately, our CPC also uses the word settlement, so I think we have got it. How about saying we will make a creative and a customized agreement just for you? Which I feel the parties will then say, ನನಗೋಸ್ಕರನೇ ಇವರು ನನಗೆ ಬೇಕಾದಂತಹ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Again, it's only a language. I'm only just trying to change language of the people. Insofar as concepts are concerned, it's the same concept what they are learning and what we have. In fact, I'll tell you in my conclusions where we stand better than them. But the words that are used, the phrases that are used at the correct time, that I think we have a long way to learn for. So, how does a mediator invest? Anyone who has taken refresher course, have you seen these three words? How, what, and who? Only few have seen it. Yes. So, how, what, and who? These are the three questions every mediator should ask herself or himself during the mediation session. So how do I do this mediation? How do I intervene? I intervene with the process that I have. So I intervene to facilitate them. And what do? I address that problem or help them evaluate their problem. And who do I do? It is the people. So if we are keeping in our mind these three questions, I think our mediations, all my processes, whatever you have learned will start coming to your minds. So opening statement, I'm going to like very few things. What's the time? So I have another 10-15 minutes. Yes. So opening statement, how many of you have heard of solar? Yes. So solar is for how the mediator will sit. Anybody can tell me what solar is before anybody falls off? Yeah, shoulders. S is for shoulder. O is for open. Yeah. L, lean towards the person you're talking. E is eye contact. And R is relax body language. So for like that, for opening statements, Alan Lepior says, try portal. What is portal? Is you present yourself first. Now, this is one thing that I saw. While you can take note of it, they thank the parties so much. I wondered why. Whether it really makes a difference, that's a topic for discussion. They thank the parties for having participated in the mediation, being part of this, and giving them an opportunity to help them to find a solutions. I don't know whether it helps in our culture or not, but you're all open to try this. So thank the parties and the advocates for having participated in the mediation. So O is for what are the objectives of mediation, you can say. For all youngsters, We don't have any new, only my co-mediator is here. So how do I do? Oh, there is one more there. So how do I do my opening statement? So in a sheet of paper, if you're going to just put portal, then you can say what is each one, and then you elaborate on that. So I have brought it. I don't know if this definition has become popular or not, but if it does become popular, remember you will be the first ones to have uh, kind of understood it. So R is for rules for engagement, T is time and process. Again, A is for agreement. So they have two agreements. First agreement to mediate and another agreement to finish mediation. We are not concerned with the first mediation. Okay, now this is Hoffman's 10 principles of mediation. What he says, every mediator, if he or she is going to follow these 10 principles, then you have a mediation agreement on your table. So we will go with the first one, conflict of interest. Conflict of interest has got two aspects. The first one, okay, I think I have do not harm first. So let's see how this works. Let me run through this. So, competence and role boundaries. What they advise or what is suggested is that in a given case, in case a mediator feels she or he is not competent, they say you should leave the mediation. Please do not do a mediation which you feel you are not competent to do. It could be some very engineering aspect in a mediation. You are not informed or equipped to do it. They say, please don't do it. And there is no shame in giving up a mediation if you feel you're not competent to do it, of the subject matter of the mediation. So, Varunana Arbhata, ನನ್ನ ಮಾತು ವರ್ಣನಿಗೂ ಇಷ್ಟ ಆಗ್ಬಿಟ್ಟಿದೆ ಅನ್ಸುತ್ತೆ, ಅವನು ಬಂದಿದ್ದಾನೆ. So, impartiality and voluntary and confidentiality, I'm not going to touch. It's more or less what principles we follow. What I will do is I'll take you all to do not harm. So this is a principle that is borrowed from the Hippocratic Oath of the doctors. This is, if you can't help in mediation, mediator's duty is to see that you do not harm the mediation. So you always need to be conscious that I should not harm the mediation, so that the parties get another opportunity to start. So I intervene so much that I bring more chaos to them than they were. So this is one of the principles mediators should keep in mind. Then self-determination. So imposition of mediators view. Self-determination, we say parties have to decide their own solutions. So what happens? This is a $1 million question. Should mediator give their views? Let me tell you, friends, even they are as confused as we are. They also don't know what is the correct way to do. But of course, ನೀವು ಕಾಯಿನ್ ಹಾಕ್ತೀವಿ ಅಥವಾ ಒಂದು ಚೀಟಿ ಹಾಕ್ತೀವಿ, they feel that these are all not practices which a civilized society does according to them. But I reminded them that in Queen versus uh, Douglas, when they decided to kill, this is the crime on high seas. I don't know how many of you remember. It's a crime which high seas. Can you kill a person for necessity? So that's the case. And in that, they choose to kill the first boy after putting a chit or like a toss, and then they decide who should be killed. So they feel that these are all 16th, 15th centuries concepts of doing it. So then what is the way out? Should the mediator give a suggestion or no? So the rule is mediator does not give. And if the mediation is failing, so be it. That is the rule. But having said that, every rule has an exception. So what is suggested is you try to tell your view in a private session, in both private sessions. And if it meets, that means your view is accepted by both the parties, then you tell, you bring it as a suggestion from the other side. You understood what I'm saying? With their consent. Yes. So you tell both places, ಹುಡುಗ ಹುಡುಗನ್ ಮುಂದೆ ಹುಡುಗ ಒಪ್ಪಿಗೆ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ, ಹುಡುಗಿ ಹುಡುಗನ್ ಮುಂದೆ ಒಪ್ಪಿಗೆ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ. ಸೊ ಇಬ್ಬರಿಗೂ ಸೆಪರೇಟ್ ಆಗಿ ಕೇಳಿ ಆಮೇಲೆ ಅವನು ಒಪ್ಪಿದ್ರೆ ನೀವು ಒಪ್ತೀರಾ, ಸೊ ಆಯ್ತು. ಸೊ ದಟ್ಸ್ ಹೌ ಯು bring is one suggestion, but that was also not, Mr. Hoffman says that also is not a best way, but his suggestion is let the mediation go. If they want, they'll figure it out. Then we have informed consent. Now, what we had been taught as we're growing up is mediation is a process which is party centric. Slowly, they are not now feeling it should only be party centric, because the parties can agree every anything, and mediator is then bound to put that into an agreement. So they feel the party should have an informed agreement. Now, how can we have the parties informed? It is only through advocates or someone else, and it is not the duty of the mediator to have the parties informed. Am I clear? All got it? So that is there's a distinction between a legal advice and a legal information. Yeah. Yeah. So there's a difference between. So what I'm trying to say here, that while we have understood mediation to be a party centric process, when it comes to agreement, it could be possible that the parties want to agree something which may be in violation of any given law, or maybe they may be uh, ignorant of certain things. Mediator may know. Now, is it the job of the mediator to advise? If you do like this, tomorrow something else will happen to you. Like it happens, for example, breach of contract. There are goods which have come, and then both of them agree and violate the law. Is that possible? So at that point of time, it is advised that mediator cannot give legal advice. For that, advocates are the only persons who has to give legal advice. So parties have to be informed. So if a mediator feels that in a given case, the parties are doing a very innocent agreement will have a ramifications later, it's not the duty of the mediator to give advice, but only tell the parties, please get advice and then come back, and then we can make this mediation. But legal information you can give. What do I mean when I say legal information? Like, let's say Supreme Court has given guidelines about how to parent. It's a guideline that has come about, which is in public knowledge. So that is a legal information. But a legal advice that if you're today going to agree for this amount, tomorrow you may get into this, or your tax limit may become something different. That legal advice mediator cannot give. So mediator needs to be conscious to have a division between legal advice and legal information, and every agreement has to be an informed or with an informed consent by the parties. The consent need not be just consent. Like we also many times say, ನಾವು agreement ಮಾಡಿ ಕಳ್ಸೋದು ಅದು ಅವ್ರ ಇಷ್ಟ ಏನಾರ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ. So to that there is a rider. Then we have, okay, duties to third parties. So they feel that mediators have a duty to third parties. Now, what do I mean? Let's say you're doing an agreement between two brothers who are taking care of their aged parent, and then they agree something which their aged parent may not want it that way, or it could be do with the children. Now they say that the mediator has a duty to that third party, and therefore what should the mediator do? If it is harming the third party, they advise that you cannot have such an agreement. But in our case, I think it will be a little different, because we are doing mainly court annexed, and then that responsibility is not with us, because ultimately the court is granting. Let us say in a case of a minor, in a case of a person suffering from any mental illness, in such cases, maybe we do it, and then it's for the court to decide whether it is legally fine or not. That is for us. But generally, the one of the principle is that mediator does have a duty to third parties. Okay, the conflict interest I had left out. There are three aspects in conflict interest. One is, of course, direct conflict of interest. You know the parties, you know the advocates, all of those. There's no difficulty in that. Obviously, you cannot take. Now, indirect interest conflict becomes quite tricky. So, what do we do at that point of time? So, there is this Paul Frank Sander who says, apply this principle of headline testing. How would you feel about the potential conflict appear in the first page of the newspaper tomorrow? So, it means ask yourself this question. ನಾಳೆ ಎಲ್ಲರಿಗೂ ಗೊತ್ತಾದ್ರೆ ನಾನು ಈ ತರ ಗೊತ್ತಿದ್ರು ಸಹ ನನಗೆ ಕಾನ್ಫ್ಲಿಕ್ಟ್ ಇದ್ರೂ ಸಹ ನಾನು ಈ ಮೀಡಿಯೇಷನ್ ಮಾಡಿದ್ದೀನಿ, ಅವಾಗ ನನ್ಗೇನಾಗುತ್ತೆ ಅನ್ನೋ ಪ್ರಶ್ನೆಯನ್ನ ನೀವು ನಿಮ್ಮನ್ನೇ ಕೇಳ್ಕೊಳ್ಳಿ. ಅವಾಗ ನಿಮ್ಗೆ ಅರ್ಥ ಆಗತ್ತೆ ಈ ಕಾನ್ಫ್ಲಿಕ್ಟ್ ನೀವು ಮಾಡಬಾರ್ದಾ ಮಾಡಬಹುದು. This is one just way I thought I will put. Now, what he says, the biggest conflict in mediation is the various biases which the mediator has. And unfortunately, I want to tell you all that in these 15 years of my experience in the mediation center, we have not addressed this issue at all. We have spoken, but not enough addressed. We need to have more and more classes or courses on, especially on this subject. And I feel we have not done. We have not even given attention to. Yes, yes, I know Shukumar had arranged, but that was not in the mediation center. That's what I'm trying to say. We have done it outside for people. There's so many people who would speak about it. Mr. Shukumar had arranged it for us. Did the bias? Yes, but we've never discussed bias as a conflict. Oh, with the no, but I think maybe I stand corrected if you have all discussed before. I personally feel this is a very important aspect where we do not deal with our own. So there are four different biases. Let's see what they are. One is implicit bias. I'll talk a little more about it. Confirmation bias. Anybody can tell me what is confirmation bias? No? Madam Sushila can tell. Heli, madam. So confirmation bias is that you confirm to yourself one view, and then you are biased that that is the view. Now, when you are mediating, you will very quickly come to the conclusion that this is the best way this has to be solved. Now, that becomes a confirmation bias in your mind that you will never ever change. And the mediation will not happen, is what the view is. You may have successfully done a mediation after that. ಇವಾಗ ನಮ್ಗೆ ಮಾವಿನ ಹಣ್ಣು ತಿನ್ಬೇಕು ಅಂತ ಆಸೆ ಇರುತ್ತೆ. Unless and until I don't eat it, I won't know what it is. So I have to experience conducting a mediation without a bias. Only then I will enjoy that fruit. That it happens by itself is good. I'm happy. It's like it having that mango drink. What is it called? Just like mango it is. There's a difference between mango fruit and the drink, right? So having a mediation without a bias. And look at it this way. It will make you a better person than what you are. How do you like that? What is affinity bias? Friends, they have the worst affinity bias than we have. At least now it's for jati, color, language ashte. So they have black, Hispanics, Asians, South Asians, and within themselves, among the whites itself, they have so many. I believe they had a research done where there was a white doctor who was prescribing less painkillers to the black and better painkillers to the white. No, these are all there. I mean, these are all published studies. Published studies. So they feel affinity bias is a. Then you have a halo effect bias. Halo effect bias is you just get impressed with somebody. There's a halo effect. Somebody comes and somebody they speaks and you just get very impressed, and then you get carried away. So that is a halo effect. So how do I get over this? How do I get over bias? Okay. All of you can take this test called implicit association test. Before you all take, there are a lot of disclaimers there. Please read it properly before you all take this test. There is no compulsion to take. I will tell you what it is. Implicit application tests are conducted by two people, Wikipedia and Google. You just need to type implicit association test and you will get questions on various subjects. It could be on gender, it could be on racism, it could be on your very thoughts. There are about 16 to 17 subjects. In each subject you click, you'll get various questions. You just follow it and it will tell you how biased you were. And they say almost 95% of the people who took tests have been moderately biased. So I think it's human. So to promote mediations, I have these no, I can't say bar councils, Advocates Association in the US have got videos made where their prominent people speak with case examples as to how the judges are so biased and how you will get judgment bias and therefore mediation is a better option. So that's how they start. And of course, the next one is to have some education on emotional intelligence. Now I'll correct myself. We did have a talk on emotional intelligence, which I myself have given. How many of you have seen that video? Lala. Only the ones who attended must have seen it. So I had spoken about emotional intelligence, and we have not seen. It's just that we have not given attention to it. So, biggest conflict, unseen conflict of interest is biases. And as mediators, if we want to be professional, whether it's court annexed or outside, we have to get over all kinds of biases or at least learn towards that. See, after all, we are humans. So we are not going to be a situation. Sthita pragna, I don't think is not there with us. But we can always better ourselves from one point to another point. We can always keep moving. And that is what is emotional intelligence. One, of course, I have given a talk, and Goldman has a lot of material on this. And if I ask Shiv Kumar, he'll say, don't go to Goldman. He has a lot of material on this, our own. So, yes. So now tell me what is, after hearing bias, difference between neutrality and impartiality. When is a person compromises being neutral, and when do you think a person is partial? Just thought. You don't know, no right, no wrong answers. Sorry? Leaning towards one party, I can't tell who said. Sir. Leaning towards one party is what? No, ಐ ಆಮ್ ಆಸ್ಕಿಂಗ್ ನ್ಯೂಟ್ರಾಲಿಟಿಗೂ ಇಂಪಾರ್ಶಾಲಿಟಿಗೂ ಏನ್ ವ್ಯತ್ಯಾಸ ತಮ್ಮ ಅಭಿಪ್ರಾಯದಲ್ಲಿ? ಸಾಮಾನ್ಯ 90% ಅವ್ರು ಹೇಳ್ತಾರೆ ಎರಡು ಸೇಮ್, ಅದಕ್ಕೆ ಜಾಸ್ತಿ ಡಿಫ್ರೆನ್ಸ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಹೌ ಮೆನಿ ಆಫ್ ಯು ಅಗ್ರಿ ಇಟ್ ಇಸ್ ದ ಸೇಮ್? ನೋ, ಇಟ್ಸ್ ನಾಟ್ ಸೇಮ್ ಅಟ್ ಲೀಸ್ಟ್, ಬಟ್ ವಿ ಡೋಂಟ್ ನೋ ವಾಟ್ಸ್ ದ ಡಿಫ್ರೆನ್ಸ್. ಯಾ, ಎಸ್ ಮಂಜುಳಾ. ಎಸ್, ಐ ಡೋಂಟ್ ನೋ, ಯು ಟೆಲ್ ಮೀ. To the party. So it's process and parties. Well, very close to it. That's exactly what Shivkumar is telling. I have taught this and she's come to teach the same thing again. No, I'm not teaching. Shivkumar, what I've been learned, I'm sharing with you. Another thing which including me, this is an advice that I give to myself, that we are not preparing for our mediation sessions. This is an advice to myself as well. Because for whatever may be the reason, you can tell me ಮನೇಲಿ ಅಡಿಗೆ ಮಾಡಬೇಕಿತ್ತು, ಮಕ್ಕಳು ಸ್ಕೂಲ್ ಕಳಿಸ್ಬೇಕಿತ್ತು, ಸೀನಿಯರ್ ಆಫೀಸ್ ಹೋಗ್ಬೇಕಿತ್ತು, ಅಥವಾ ನಾನು ತುಂಬಾ ಸೀನಿಯರ್ ಈಗ ನನ್ಗೆ ಇವೆಲ್ಲ ಮೀಡಿಯೇಷನ್ ಸುಮ್ಮನೆ ಹೋಗಲ್ ಕುತ್ಕೊಂಡು ಮಾಡಿ ಬರ್ಬೋದು. ವಾಟ್ ಆರ್ ದ ಸ್ಕಿಲ್ಸ್ ದಟ್ ಐ ನೀಡ್? ಐ ಆಲ್ರೆಡಿ ಹ್ಯಾವ್, that is our thinking, including me. So I'm not. So we need to sit with our file. They encourage you to read your file while we were taught, don't read the file, do it that yourself. So you can structure your opening statements once you just go through. Now, when I mean go through, don't need to get judgmental after seeing what they have given. So that is where your implicit bias has to stop working. And you have to keep telling yourself, see, we have also learned mind will work what we tell the mind. Correct? So if you are going to tell the mind that you cannot be judgmental, it won't be judgmental. So face will come to you. That's the reason why we are all encouraging senior, good looking people to be mediators. So as we become seniors, these are something life skills that we can learn. And let me tell you, I am enjoying learning. And I told you, this is one of the best things that's happened to me that mediation has taught me to invent myself. Whatever core values that I had forgotten somewhere. With these dreams, I want to go here, I want to do this, I want to do that, I want to have the best of cases, I should be always appearing before the courts. All these things have somewhere lost. What are the true ethics that we are doing for our this one? Maybe it's nice sometimes to sit, and if you truly do it, let me tell you, friends, you will all enjoy it. Okay, now let's see what Hoffman says to be difference between neutrality. It's a mediator's ability to be objective while facilitating communications among negotiating parties. Whereas impartiality is freedom from favoritisms and bias. So if I'm biased to somebody, I can still be neutral. But if I'm biased to somebody, I compromise on neutrality also. You can't say I can be one and not the other. That way, each one is interdependent. You need to be both. But both are different. Like in the class last time I took, we were discussing about what's the difference between envy and jealousy. What is the difference between envy and jealousy? At least those persons who tell their mother tongue is English, like us, at least we should know.
Envy is perhaps,
Jealousy is strong emotion, but what is the
and envy is perhaps something that you uh, desire. I mean, you see someone else and you desire it, but you don't have that negative emotion towards that the person having
in an
it.
envious
Yeah.
situation? Yeah.
In jealous, it is totally negative.
Yeah.
You are
So
unhappy that the person is.
good one. Please give her a hand. So jealousy always comes. So like this, we have 10 to 15 words in English, which feels the same and we use it interchangeably. So when we do that, we are not able to identify emotions of people. That's what happens. So envy and jealousy. Jealousy, though it has a negative, jealousy creates a fear in you. Though it's a negative term, it creates a fear. So when a party is jealous of another, the party is having fear. There are five emotions, no, that we all have. Five negative emotions. Please tell, otherwise Shikumar will think ನಾನು ಹೇಳ್ಕೊಟ್ಟಿದ್ದೆಲ್ಲ ವ್ಯರ್ಥ ಆಯ್ತು ಅಂತ. Five negative emotions. Okay, let's move. Friends, are we all good? Yeah, just few more minutes. Okay, so emotions. It's a vast subject. We can't possibly cover in anything. We had very good exercises that I can't do, but if at all I am in any refresher course, 1 day course, I'll include those exercises. So when I take, you can all come. So they say emotions in a person will always be, we're only dealing with negative emotions because mediator only deals with negative emotions. It is like a cup of hot water or tea. You cannot touch it on from any angle except the holder. So when you are dealing with an emotion with a person, you should never touch them and always have some external aid to help them to get over those emotions. So it is like a hot cup of tea or coffee. You cannot touch in any side. Whichever side you touch, it's going to be hot. So you have to have an external link to get out of that emotion. It's just a simile. So then we have, sorry, mediator is the holder. No. Mediator uses a skill which becomes a holder to lift that emotion up. Um, then you have various different emotions. There are patent emotions, latent emotions. Any has any doubt? Patent emotions are that which is quite patent. It's there outside. There are some latent emotions which we can't see. Again, that's what I'm saying. We have to learn these words as mediators. We have to learn these words. ಅಯ್ಯೋ ಅವ್ರು ಹೇಳಿದ್ದು ನನ್ಗೆ ಅವ್ರಿಗೆ ತುಂಬಾ ಕೋಪ ಆಯ್ತು, ಒಳಗೆಲ್ಲ ಜಾಸ್ತಿ ಕೋಪ ಆಯ್ತು. ನೀವು ಲೇಟೆಂಟ್ ಇಮೋಷನ್ಗೆ ಕನ್ನಡದಲ್ಲಿ ಉಪಯೋಗಿಸ್ಕೊಳ್ಳಿ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಬಟ್ ಪದ ಬಳಕೆ ಬಹಳ ಮುಖ್ಯ ಅನ್ನೋದು ಐ ಫೆಲ್ಟ್, ಬಿಕಾಸ್ ದಟ್ ವಿಲ್ ಹೆಲ್ಪ್ ಯು ಟು ಅಸೆಸ್ ದಟ್ ಸಿಚುವೇಶನ್. So we have done only one aspect of identifying emotions. There are four aspects of identifying emotions. There are different exercises for that. I don't have time to do it. So you have active listening, active sensing, and active perceiving. So you have to keep on perceiving, sensing, everything together. There are good exercises for that, but I won't do. Okay, this is one serial that I want to recommend. Whoever is interested, it is a late 19s or 2000, early 2000. Lie to Me. Only whoever wants to learn about body language can see it. It's a very expert serial about a detective who detects whether a criminal has actually committed the crime or not, depending on his facial expressions. So that will help you to. Uh, I don't know if that's serial, but as I told, whoever is interested to see, I watched 2 episodes. I felt it was too much for me. So now he is another guy, Paul Eichmann. Paul Eichmann has given a lot of, he has done a lot of work on emotions. So whoever wants to learn on emotions, please read Paul Eichmann. Now he says, and I'll read, emotions are a process, a particular kind of automatic appraisal influenced by our evolutionary and personal past, in which we sense that something important to our welfare is occurring. So that means you have to change that emotion of the person to make him or her feel something good is happening to them through mediation. That is our job, because that emotions has that capacity to make the person feel that something good is happening to me, and it is our job to do that. He has written hordes of articles, hordes of books. Please do this. Okay, now this is very interesting. Almost done. uh, this is an article written by Alan Rapior. He was one of my resource persons. Gender and role in conflict management. According to their study, female mediators or female third party mediators have much better mediations than the male, with no offense to any of my male members. With no offense to any of my male members. That is his study. I'm not saying that his study is ultimate. Why so? Because he says a female mediator gets into a eschewing behavior, whereas a male mediator becomes an agent behavior. So, male, as I said, no offense. Please do not tell I am saying this. This is what I just say. We had for 3 months, it is to send us material and material to study. So, this was one material that caught my eye, and I thought I should share with all my female mediators. So, I have a personal bias in doing that. I had a personal bias in doing that. So, female mediators have a better behavior. Okay, this is some interesting things. Just look at how their society is. Women experience sexual violence by an intimate partner in their lifetime, 36.4% of women. And black women have the most. And at least we are lucky we have just binary system still. In our mainstream, we don't have beyond binary system, but they have to deal with so many of it. I really pity them. So these are some of the works. If anybody wants to read, this is a good read. I don't know if you can read it, but I have written them down. Mediation Ethics by Ellen Waldman and Theory of Mediation Ethics. Everything will get it on online. I have not chosen anything that is not there. In fact, there are many audio books also of this. It is only that we should take time to read it. Yeah. Can I change the slide? Yeah. So, what is the area of focus as mediators? I've already shared with you. I think overcoming bias. If we are able to overcome bias, we'll have better mediation sessions. That's my view. Two, you have to follow the process, whatever process you're. And that is where I say you have to go back, read what is it that I'm going to do in this session. We don't do that. What skills will I employ? What process will I employ? Those. Conclusion suggestions, I really don't have much of conclusion suggestions. Somebody had a question to me last time that I am quite biased. I know I have a very strong bias. What should I do? I had advised on the last occasion that you have to help yourself better. But I am now advised to say that if you feel you have a bias on any issue, please do not take that issue for mediation. I think Biju or somebody had asked me last time in our session that he had a huge bias when children are involved or something. So, what do I do? So, the answer is please don't take such mediations. You can always say, this is not for me. And we had an interesting video this morning, want and need or something. Somebody sent you know, what's the want and what's the need? Need is, of course, air, food, everything. Want is what you desire, is what it was saying. But one nice thing he said, love. Whether love is a need or a want. What is it? Both. Yeah. So so love by itself is a need. That you want love from Vaishali is a want. So the mediator's job, see, in all situations, you may not get love, I mean, rather, you may not get what you want. So the mediator's job is to have that emotion molded in such a way that I feel good getting love or what I want from X or Y or get in my given situation. This is what is best for me. That is the job of, because ours is interest based and needs based. That's what we have. So what are my suggestions? I really don't have much of suggestions. I already said we all need to work hard. We are not doing. So we have to study materials. And we don't have enough material sangrahane with us. Mediators, whenever you have good experience, please write a blog. Please write about what is the skill that you used. When you read from external material, you can relate it to what you're doing. And then you can write an article. If we open in India, few authors, I'm blessed that I have few authors sitting in front of me and quite humbled that they've come to listen something which they don't know. But nevertheless, that kind of material in India we have to build because we are culturally different. So if we want mediation to flourish in this country, we have to contribute. Even in England, sorry, even in America, mediation started in 1970. So they don't even have a second generation mediators yet. So from that angle, we are still child children mediators in the sense for the entire posterity. So we have to collect information. So keep writing something, and I urge DD ma'am to probably open some portal in our website that somebody who has written will upload it.
Please, with this, let us start and kindly start writing articles and we publish it on our. Keep it short so that we can have as many articles as possible in a edition. 2 months ago, this was put on your notice board, but there is no response. Please do it. Thank you.
It's for posterity. We need it. People who come after us need to know what we did, and you are all the pioneers in mediation in India. I mean, if mediation is going to survive for the next 50, 60 years, we won't be there, but our work will stay. Like, for example, I showed you the gender and anything, any good incident that you have. What was a trick that you used? Yeah. And one more suggestion I thought, Madam says, we could have co-mediations when it is a very complicated or difficult case, so that one mediator can hold the fort. I know I'm entering into a devil's den here, but it certainly requires discussion. Like, for example, we are now doing co-mediation, I'm unable to do so, or come, the person also gets to learn, then we both sit and discuss. But of course, co-mediations can happen between two people who can get along. Please do not have co-mediations. They're very popular now. So what has happened is, in United States now they are doing more caucus mediations. That is private session mediations. They don't even allow parties to talk to each other. So one party is on this side, one party is on that side. So this is giving a lot of doubts to the very transparency of mediation. So to get over that, they're doing co-mediation. That means the two people, so that it's more transparent. So same thing can happen here also. There are two mediators for an important and high stake matter, then very sensitive matter. Then they've been they'll be it's much more transparent. Was my suggestion. And in the end, I just want to say that our module of mediation and what we are doing here is the best. And on this note, yes, on this note, of course, few suggestions that I made, but overall, our pattern of imparting training, the concepts that we have is very good. It is just that we could possibly, that is where, I mean, I think it is a very like we are very good, like it is even in case of engineers, you're all very good, but when it comes to organizational skill, we go. So that there, I think if we work a little bit, we can do a lot for mediation, but otherwise it's a so I humbly thank all of you all for coming today. I can see so many of the senior mediators have come. Thank you so much. I know I have not given you anything that you all didn't know. It is just the happiness that what I enjoyed. And I was fortunate, or how can I say, I was lucky to just go and I had the means. It's not economically, it's not a very viable uh, course also to do. But the experience was invaluable. And I thank our DD and our Deputy Director for giving me this opportunity. Thank you all, friends, for coming. Namaskar. Any questions anybody has? No, it's the, huh. If the audience in Kalburgi and Dharwad have any questions, please post it in the chat. I will try and answer it. Thank you so much. Yes, I did a negotiation masterclass session. No, that is more of a commercial one. It's not so viable to our way of doing. So that's more to be a good negotiator. So you are a person who facilitates a negotiation. That is, that course is mainly for, CEOs of companies, a corporate person who sits at the negotiation table. Even lawyers who sits for a person who negotiates. Otherwise, it's a very interesting subject. And then we did a mediation between countries. So the role play was speaking to the ministers, to the diplomats, and to the head of governments, and to the head of the Naxalites. I mean, I wouldn't say Naxalites or the terrorist groups, whoever. So that way it was, you are getting trained to become an international. So they're very nice that we don't have questions, that only shows that whatever I said was understood by everybody, and there's nothing more to say. So I rest.
Madam,
Huh.
your Harvard experience will help us to go forward
Oh, thank you so
in
much.
mediation.
Oh, it's a feedback. Thank you so much. Thank you so much. Anything? So if Dharwad audience or Gulbarga audience have something else to say, please post it. We'll try and so we can have a WhatsApp group or something. I know I'm again entering into a very dangerous den. When we used to Earlier we used to discuss on some issue. which of course can get a little bit tricky at the end of it, but at least there used to be some stimulus.
Hello, madam, from Gulbarga bench. Hello. Hello, madam. Madam, are you listening? Have you got the audibility from Gulbarga High
Yes,
Court?
sir, please tell.
Madam, just in your lecture, you discussed about the legal information and legal advice during the course of mediation. But it so happens that the mediator, while giving some practical suggestions, ultimately the parties they try to take the advice of legal advice rather than going for legal information. How do you elaborate on this point of view? Because you just said that the mediator shall not go and restrict himself only to the extent of solutions, because ultimately the lawyers who come to the conclusion of settling the mediation. So that is very important and crucial period in the course of mediation. Can you just elaborate that how far that mediator can go and give solutions in respect of legal advice and legal information?
So we're running out of time, but I will try to sum it up in very, very little few words. Sir, a mediator's job is not to advise the parties as to what they should do or what is the legal consequences of their agreement. Now, if you come to such a situation, you have to involve the advocates, their advocates. In case their advocates are not there, you'll have to tell them, ದಯವಿಟ್ಟು ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಜೊತೆಗೆ ಈ ಪ್ರಶ್ನೆ ಕೇಳ್ಕೊಂಡು ಅದಕ್ಕೆ ಸಮಾಧಾನ ತಗೊಂಡು ಆಮೇಲೆ ನೀವು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ನೀವು ಅವ್ರಿಗೆ ಹೇಳ್ಬೋದು. ಆದ್ರೆ ಯಾವ್ದಾದ್ರೂ ಇವಾಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ನಿಮ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಫ್ಯಾಮಿಲಿ ಮ್ಯಾಟರ್ಸ್ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್ ನ ಟಾಪ್ ಪ್ರಿಯಾರಿಟಿ ತಗೊಳ್ತಾ ಇದ್ದಾರೆ, ಅದು ಕಕ್ಷಿಗಾರಿಗೆ ಗೊತ್ತಿರಲ್ಲ. ದಟ್ ಈಸ್ ಎ ಲೀಗಲ್ ಇನ್ಫಾರ್ಮೇಶನ್. ದಾಟ್ ಇನ್ಫಾರ್ಮೇಶನ್ ನೀವು ಕೊಡ್ಬೋದು. ನಿಮ್ ಕೇಸ್ ಇವಾಗ ನಮ್ಮ ಕೇಸನ್ನ 4-5 ವರ್ಷ ಆಗತ್ತೆ ಸರ್ ಅಂತ ಹೇಳಿದಾಗ, ಇಲ್ಲ ಇವಾಗ ಫಾಸ್ಟ್ ಟ್ರ್ಯಾಕ್ ಕೋರ್ಟ್ಸ್ ಆಗಿದಾವೆ, ದಟ್ಸ್ ಅ ಲೀಗಲ್ ಇನ್ಫಾರ್ಮೇಶನ್. ಬಟ್ ನೀವ್ ಈ ರೀತಿ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಅದ್ರ ಪರಿಣಾಮ ಈ ರೀತಿ ಆಗ್ಬಹುದು ಅನ್ನೋದು ಮೀಡಿಯೇಟರ್ಸ್ ಕೊಡೋದು ಸೂಕ್ತವಲ್ಲ ಅಂತ 10 ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. ಅದನ್ನ ನೀವು ಫಾಲೋ ಮಾಡಬೇಕು ಅಂತ ನನ್ನ ಅಭಿಪ್ರಾಯ. ಧನ್ಯವಾದಗಳು. ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಫ್ರಮ್ ಎನಿವನ್? ಫೈನ್, ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್. ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು ಸ್ಟೆಪ್ ಡೌನ್.
Am I audible now? Thank you so much for this opportunity. I take this opportunity to thank Honorable Patron-in-Chief, Honorable President, Honorable their Lordships, the Board of Governors of Karnataka Mediation Center, and I thank Srimati Anuradha SR Madam for her insightful and thought-provoking session on various aspects involved in this aspect of mediation. And I, on my personal behalf and on behalf of everybody present over here, both of the dais and online from both Gulbarga and Dharwad, Madam, thank you so much. And I would like to extend my thanks to our respected Director, Madam, Karnataka Mediation Center, for all her guidance in arranging program of this kind. And I thank on my personal behalf and on behalf of everybody present over here. Madam, thank you so much. I would like to take this opportunity to thank all the respected mediators of Bengaluru, Dharwad, Kalburgi, who are present personally here and online as well from Dharwad and Kalburgi. I thank everybody for your active participation in this thought-provoking session. Thank you so much. And I thank Honorable Additional Registrar General, Dharwad, Kalburgi, Additional Registrar Judicial, Dharwad and Kalburgi, for their support and advice in arranging the program of this kind. Thank you so much, sirs and madams. And finally, I would like to extend my thanks to all my dear staff members present over here who have extended their help to arrange the things here for having a very smooth session. And I thank everybody present over here. Thank you so much. Thank you, one and all. Yes.